Well, that is if you're in the Mountain Time Zone or the Pacific Time Zone. Other time zones, good afternoon. Now that you've spent the last hour hearing about why to avoid probate and testamentary trusts, I'm going to tell you about testamentary trusts. This topic is simple testamentary trusts and revocable living trusts. At the end of my outline, I've attached, NBI attached for me nicely, 3 documents. One, I believe the first one is a testamentary trust from like the early 60s. It shows you how complicated it can be to set up going through probate. It's a multi-page document, a probate court order. The next is, I believe, my sample will that creates a testamentary trust on the death of the first spouse. That's like the only one I've done in the last 20 years. And the last is my typical husband-wife set up a Q-tip trust, a revocable trust, just for forms. But the first topic is when are testamentary trusts used? Lots of people like to avoid probate. Some don't. So why would a client come in and say, no, I don't want a revocable living trust. I want to do a will and create the trust on my death. It's really a question of pay me now or pay me later, penny wise or pound foolish. Trust, especially when you do the funding, and make sure the assets are in there involved with the clients, to make sure that they put their real property in and they put their larger bank accounts in, and you cross-check against the beneficiary designations, on IRAs and 401ks. It's much more expensive than setting up a will with a testamentary trust. Then you explain to your client, well, let's say you have just $1 million in assets, gross value, your house. There's very few parts of California that your residence is going to be worth less than $1 million, and that goes through probate. Even if it has an $800,000 mortgage, the fee for the attorney handling the probate is going to be $23,000 by statute, and the fee for the administrator, who may or may not waive their fee, is also going to be $23,000. So it gets very expensive when you probate an estate. There's also out-of-pocket costs in a probate, publication, the probate referee to appraise the property, publication costs, things like that. So it's penny wise and pound foolish if that's all they're thinking, but people do that. So if a client comes in and says, no, I don't want to pay for a trust, I just want to do a will right now. Okay, fine. Another reason to, at least in the past, to use a testamentary trust is probate is a good vehicle for handling creditors' claims. If you have a revocable trust and the first spouse dies and you set up the sub-trust on the death, there's no cancellation of creditors' claims. The 1-year statute limitations applies, but there's no way to sort of ferret out the creditors' claims that you can do in a probate with publication and notice of administration. And however, since January 1, 2016, I wrote the effective date down there, the legislature set up a corollary procedure for revocable trusts where you can publish a notice for your revocable trust, inviting creditors to submit their claims, just like they do in probate. And if they don't do so within a certain period of time, 4 months after publication, they're out of luck. It doesn't mean that the terms of the trust are public. It's just you're telling creditors to put up or shut up. So in the last, 8, 9 years, I've never seen it used. I've never used it. I've never seen it used. I don't know why. I think it's a valuable tool, but you'll find it in probate code sections 19000 through 19403. It's a way for evening out the playing field between revocable living trusts and testamentary trusts in terms of getting rid of creditors' claims. Another reason someone might want a testamentary trust, which you have to probate the will and then create the the trust at the end of the probate, is court supervision. A lot of times there's difficult issues, and maybe your client wants their trustee to make sure that everything they do is approved by the court, so that none of the beneficiaries can then go back and claim that the trustee committed breach of fiduciary duty or negligence or anything like that. Of course, if the trustee is committing actual fraud and fraud on the court, court supervision isn't going to help the trustee in that case. But if the trustee advises the court and the beneficiaries what's going on, beneficiaries don't like it, but the court says, yes, this is the way it's going to be done, and there's no appeal, then that's the end of it. It protects the trustee. Now, you can get ongoing court supervision with a revocable trust, but it's very uncommon. The only reason you'd want to do that is if there's a lot of litigation and there's a lot of concern about how the trustee is behaving. So maybe somebody files a petition for removal of trustee. The court might say, you know what, I'm going to supervise this and require annual accounting be submitted to the court for a while. So that can happen, but it's uncommon with a revocable living trust. But it much more common with a testamentary trust. You can ask at when you create the testamentary trust to end court supervision, so that the trust is created, no more court supervision. And in a smaller trust, that's a good idea, because court supervision requires annual or biannual filings, attorney's fees, court fees. It can get expensive. So unless there's a lot of issues one is concerned about, or you have a very large trust and you want to make sure it's court supervised for a while, you can also end court supervision even with a testamentary trust. The next topic is going to be living versus testamentary trusts for tax purposes. As you heard with the prior speaker, during the lifetime of both spouses, a revocable living trust is invisible. Everything is reported under one or both Social Security numbers, for a married couple, that is. It's just except for an account being titled John Smith and Jane Doe, comma, co-trustees. It's still John Smith and Jane Doe. It's pretty much invisible during the lifetime. If you create a testamentary trust in probate, you're going to need two employer identification numbers, and you're going to need two sets of tax returns from the get-go. The first employer ID number and tax return is going to be for the probate estate. The second one is going to be for the testamentary trust, because it will be irrevocable. Whereas with a revocable living trust, until a irrevocable trust is created, there's no need for tax returns. So if, for example, you set up an AB trust, meaning everything goes to the surviving spouse on the first death. If the surviving spouse disclaims, it goes into an irrevocable trust, but that's optional. So let's say husband dies, everything goes outright to the surviving spouse, or it remains in trust, but it's irrevocable. No tax returns are required, no employer ID number. And then the second spouse dies, and it's a distribution directly to the children and other beneficiaries, no continuing trust in that case. You'll never need a tax return for the trust. Whereas, as I explained, with a testamentary trust, you'll need at least two. And the income tax returns. Every time, a testamentary trust will be irrevocable, and ongoing income tax returns are needed until the trust is completed. And that was part of that first irrevocable trust, the testamentary trust, sample that I provided. The reason I got involved 30, 40 years later is the principal had fallen to a level where it was no longer economically feasible to continue to manage the trust and pay tax returns and pay it pay a trustee for that. So for all those 40, 50 years, it was filing income tax returns. Okay, next, trust funding mistakes and consequences. There are many trust funding mistakes. And again, if I know I was listening at the end of the prior speaker, if you go into court, a lot of the litigation is over the trust funding mistakes. And so I think the number one consequence is you'll find yourself in court. So let's talk about some of the larger trust funding mistakes and their consequences and maybe how to fix them. The one I see the most often is a failure to fund or a failure to return property into the trust. And by failure to return property, I've got, this comes up once a year, and I've got one going on right now where a house or other property, real property, is in a trust. And you tell the client when you're done meeting with him and you funded the trust and you made sure that the deed is in the name of the trustees actually, to the house, that anything changes, if you take it out of the trust for financing purposes, give me a call. Make sure we clean things up. They never do. So they go along, and you see this a lot because of the low interest rates that we had recently, not so much now, but in the recent past. The banks will require often the title to be taken out of the trust and into the individual names. There's no reason for that anymore. It's an old rule that's long gone, but banks are lethargic to change their ways. So your client will take the house, put it in his individual name, refi the property, and never call you, never put it back in the trust, and passes away. So now the successor trustee comes to you and says, what do we do? And you say, I have a magic word, Hegstead. It's case Heggstad, Estate of Hegstead from 1993. The site is 16 Cal App 4th, 943. And what that allowed is, if there's fair evidence, I don't know if it's good evidence, fair evidence, I don't know exactly what the legal standard is, but if there's decent evidence that the trustor intended the property to be in the trust, then we'll put it in the trust without a formal probate. So for example, if there's a Schedule A listing these assets, and it doesn't have to be real property in terms of a Schedule A. Let's say it's a large bank account. So this belongs in the trust, but they never actually changed title. The court will likely move that to the into the trust through a court petition as part of the trust, but it's not a probate, and the trust terms aren't disclosed in the pleadings. And again, in my case, the evidence that I have showing that it's in the trust, it was in the trust for many, many years. It got taken out to refi to take advantage of the low interest rate. Trustor was ill, neglected to put it back in, died 2 years later without ever putting it back in. Voila. So what isn't good evidence of a trustor wanting to put an asset into the trust is a Schedule A that says all of my real and personal property belongs in the trust. The courts have consistently said that's not specific enough. You need to say my house at 1600 Pennsylvania Avenue, Washington, D.C. Is a trust asset. My 401k at, well, it can't be, okay, my savings account at Washington Mutual, I know they're not around anymore, is a trust asset. That will work. Just saying all my savings accounts are trust assets won't work. Another common trust funding mistake, and this one is what gives me the gray hairs, is the failure to fund subtrusts on the death of the first grantor. So you've got a husband-wife situation, typically. Let's say the husband passes away. 15 years later, the wife passes and one of the kids is the successor trustee, and they come to you and say, okay, how do we handle the trust? And you look at it and you say, okay, what was done when the husband died 15 years ago? Nothing. Oy. So what you have to do, especially if there's different beneficiaries of different trusts, you actually have to go back 15 years and try to recreate what should have been done. What should have been done 15 years ago. Let's say funding a spousal trust, a survivor's trust, and funding a Q-tip trust because the beneficiaries are different. And then you got to track the income that should have gone into the trust and the distributions. Where should the distributions have come under the terms of the trust document? It requires a lot of forensic accounting in that situation, and a lot of attorney work, and a lot of conflict with the beneficiaries over, you say it should be here, they say no. It's a mess. So that's another common error. Tax basis and appreciating assets. You want to try to avoid putting appreciating assets in in a irrevocable trust on a death of the first spouse. And the reason for that is, let's say you own 1,000 shares of before the split of NVIDIA, and you bought those 10 years ago, and the client bought those 10 years ago and died, 2 years ago before they shot up. And he says in the trust, I want all my NVIDIA shares to be in the irrevocable trust on my death. He dies, the NVIDIA shares go into the irrevocable trust, and 2 years later, the second spouse dies, and the trustee comes to you and says, okay, it's a liquidating trust, we have to sell the NVIDIA shares. You're going to have a huge capital gains because the tax basis for those shares in an irrevocable trust is locked in as of the date of the first death. Whereas had they been in a survivor's trust, a revocable survivor's trust, they would get a step up in basis on the second death as well. Now, I don't know what 1,000 shares, just off the top of my mind, would be worth before the split this last week. But each spouse has $13,610,000 of estate tax exemption this year. And you want to take advantage of that and get that step up in basis so that on the second death, when you sell those NVIDIA shares, there's no capital gains. Other issues is property taxes. You want to make sure, especially with this recent Prop 19, where the child has to be the beneficiary of the primary residence and has to live in it in order to keep the low Prop 13 tax basis. You want to make sure who the beneficiaries are going to be of the house. And it can be, for example, I name John and Susan as my beneficiaries, and they each get a 50% interest in the house. But there's also other assets, and John and Susan agree that Susan will get the whole house, and John will get cash assets. That works. Another way it works is John and Susan get the house 50-50, but only John moves in. That's okay too, as long as John is a beneficiary. As an owner of the house and he lives in it, you'll get that Prop 13 carryover. Top trust administration issues. I talked about my gray hair. This is my thinning hair. Successor trustees. Everybody wants their children to be the successor trustees or other family members. Unless it's a very simple liquidating estate, that's a mistake. But clients repeat that mistake every time. If I name John and Susan as they don't get along, but this will force them to get along. Or John knows what he's doing. He's a professional engineer. He'll be a good trustee. No. You really need a professional trustee or a institutional trustee if it's a large or complicated trust for several reasons. Discretionary distributions. You don't want child A deciding have the power to decide how much to give each year to his brothers and sisters. They'll be upset if he doesn't give them enough. They'll be upset if one of the brothers and sisters gets more than another. They let them get upset at the Bank of America. Another is the attorney's fees. If you have an individual trustee that doesn't know what they're doing, and that's about 99% of them, they're going to come to the trustee the attorney for help, and the attorney's fees are going to rack up, and they're going to wind up being much more than you would pay to an institutional trustee for managing the trust. Another reason to have an institutional trustee is what I call the problem child. Somebody with, let's say, alcoholism or drug dependency, and you have discretionary distributions only if they clean up their act. You don't want one child to be in charge of deciding when his sister cleans up her act. You really want an institution to do that. Lastly, management of an ongoing business. Two issues with that. One is you have a trustee that also runs the business, right? The son that was always in the business. And even though all the children are now equal owners of the business, maybe he's paying himself too high a salary, according to Sister Sue, and that should be plowed back into the business and distributed as profits to them. Another issue, of course, is naming two or three trustees, only one of whom knows how to run the business, and the other two are sticking their nose in and making a mess of things. Finally, issues with top trust administration is appreciating versus income assets. Do you distribute capital gains out to the beneficiaries? Do you distribute current income? It's complicated accounting, complicated rules, and if that's going to be an ongoing issue, you really want an institutional trustee that understands those issues. Sample trust language. Okay, let's see, we have 8 minutes. Okay, I ran a little fast there. And then we'll turn over to questions. So sample trust language. So I'm going to click here. So, I guess it doesn't show up. Okay, so let me go back and let's see if there's anything I want to talk about. Tax returns, trust funding mistakes. Yeah, the failure to fund is I nag my clients as part of the trust package that I say I'll do the trust, the pour over wills. I also do the deeds to transfer the real property into the trust to make sure, at least at the get-go, that it's titled, and I'll bug my clients for that. If there are bank accounts, savings accounts, brokerage accounts, I will bug them and ask them if I can contact their broker or their banker to bug them to get those transferred. I don't actually fill out the paperwork for that. It's usually online, or they can go into the bank. It's a pretty simple process, but I do bug them to make sure it's funded in the first place. And again, after that, there's no knowing what the client will do. Hopefully they've listened to you, and if the circumstances change, they actually give you a call and ask you if anything needs to be done with the trust or its funding. Asset protection. Another issue with failure to fund on the first death is, let's say there's it calls for a Q-tip trust or bypass trust, and it's never funded, and the surviving spouse gets into a bad car accident. Well, and gets sued. Well, those assets are now available to the creditors. Had they been in an irrevocable trust, such as a Q-tip trust or a bypass trust, they'd be free of assignment or lien from the creditors if they had a spendthrift, which they always do. But because the Q-tip and bypass trusts weren't funded, they're considered as held in a irrevocable trust and are now subject to those creditors' claims for whatever damage the surviving spouse does, because it wasn't funded. The $13,610,000 estate tax exemption per person is going to go up next year, and then it sunsets at the end of December 31, 2025. Starting January 1, 2026, it's going to go back to $5 million per person plus inflation. So I hear somewhere around 7, 8, 9 million. Nobody knows what the exact number is going to be just yet, but it's somewhere in that range, unless Congress extends it. Your guess is as good as mine as to what will happen in between now and then. I see I have 4 or 5 minutes left. Open it up for questions. Okay, here's a long one. I'm gonna have to scroll through this. Let's see. A trustee discovers that the grantor failed to transfer a valuable artwork collection into the trust before passing away. What potential liabilities could the trustees face if beneficiaries contest the distribution of this asset under California trust law? I don't think there's any liabilities. If you can get it into the trust, if it depends who the trustee is. If the trustee is of a revocable living trust is not the grantor, and failed to do it, and it has to go through probate, and there's $10 million, $5 million, whatever, worth of artwork, it has to go through probate, and these high probate fees are due. Yes, the trustee will probably be on the hook for that. But if you can Hegstead and bring them into the trust and then distribute them out through the trust, the amount of attorney's fees incurred wouldn't be worth a lawsuit against the beneficiary. And what's a typical trustee fee? For a professional trustee or a bank, they'll charge, usually it's a sliding scale, usually it's like 1.5%. The first million, then 1.25%, and then maybe 1%. After a while, and that covers everything. Okay, it covers all the tax work. It covers the administration. It covers decisions. It does not cover attorney's fees. So if they have to go in court to get approval for something, their attorney's fees would be extra. But it's always going to be less than an individual who runs to their attorney for advice. And if it is an individual, they'll often take, advice somewhere. They try to do it by the hour, but they're not professionals. How do you pick an hourly fee? So I say, do 1.25%. The reason I don't do 1.5% or more for an individual is because they're going to be paying me on top of that, and you don't want to make it look too expensive for the other beneficiaries. How often should clients review and update their trust funding strategies to align with changes in their assets and financial circumstances? Whenever something significant happens, there's no set schedule. I'll have clients call me after 5 years, and they'll say, "Okay, what should we review our trust with you?" I said, "Okay, well," and I'll pull the trust up on the computer. It says, "Okay, what's changed?" "Well, we have another granddaughter." So, okay, well, we already covered all the grandkids. Should one of the kids pass away, so we're good there. You don't need to name the granddaughter unless you want to give her a specific bequest. What else? Well, our wealth has increased by a couple million. Okay, well, we've covered that already. And then they say, well, there's nothing to do then. 10-minute, 15-minute phone call. I don't charge for those. So in terms of how often, just if there's any significant changes in family or financial circumstances, is my answer. Because the law, ever since 1983 with IRTA, I don't even remember what it stands for, but when you had the unlimited marital deduction and things like that, the structure of trusts have not changed. What documentation should clients maintain to demonstrate proper trust funding in California? Deeds to a real property should be John Smith and Jane Smith, John Smith and Jane Smith, co-trustees of the Smith Family 2024 Trust. should be for real property. Stock certificates to either closely held or publicly traded companies should be titled the same way. Bank accounts should be titled the same way, except for your smaller bank accounts, because you have that 183,000, something like that, exemption from probate for smaller assets. Securities accounts, things like that, should be in the name of the trustee or trustees, and that's the proper documentation.
Alrighty, I will turn things over for our next segment to Vanessa Terzian. Vanessa, the floor is all yours.
Okay. All right. So actually,